Okay, the real property tax assessment issue, I think, is one of the big issues with solar leasing. Okay, it is clearly going to cause people to lose two kinds of exemptions. Okay, one kind is the farming exemption. The farming exemption is a valuable exemption, and probably the reason a lot of the farms locally are continuing on as farms. But most people will say that they paid anywhere from $800 at the low end, $1,500 at the high end. You can make more money per acre on a solar lease. Whether that's true or not, I don't know, but let's just take that for some of the feedback I've got. Now, the problem is if you lose your exemption and you have to pay for that, that's going to cut into those profits. The lease should agree to pick up any penalties. Now, some people have their property in 480A. Now, I happen to know a lot about 480A, which is the forest tax exemption law. I once wrote a law review article and compared our New York State law to 50 states' laws. And what I found out was New York State has the most heavy penalty for converting forest land from a 480A program out of the 480A program. It is the most draconian penalty situation I've ever seen in a tax law. Compare it to the agricultural law, where it's 5 years of penalty plus 6% interest. This law takes up to 9 years, 10 years of penalties, and they multiply it by either 2.5 if it's a full withdrawal, or 5 times if it's a complete or a partial withdrawal. And this in most cases would be a partial withdrawal because it's only a piece of the property. And then they add 6% interest to that. I had one client with 400 acres who ended up paying over $100,000 penalty for converting their land in a 480A situation. It's a very, very expensive proposition, and you're going to find a lot of these solar companies are going to say, well, we didn't know that. You should have told us that. You owe us the money for not telling us that. Well, they got to read the state law, but if you have it negotiated in there that they'll pick up any tax penalties for conversion from 480A or from agricultural land, you should be safe. There's other issues with the exemption that the solar power company hopes to take advantage of to keep the property taxes lower. Municipalities can opt out, okay? And the lease term is only 15 years, or 20 years long, but the exemption only lasts for 15 years. The last 5 years is going to be full assessment unless the law changes. And there could be legislative changes. We expect legislative changes because they oftentimes go back and fix these things in the next 15 years. But I can't promise you that New York State legislature can pass any law, let alone a law that affects you in the next 15 years. Now I want to read you a couple of the towns around here that are exempted, that have opted out of the exemption rather. And I'll read Chautauqua County because we're in Chautauqua County, but I have every county in the state here. In Chautauqua County, in the school districts alone, it's Bemis, Brockton, Cassadaga, Forestville, Fredonia, Frewsburg, Gowanda, Panama, Pine Valley, Randolph, Ripley, Silver Creek, and Westfield. So that's Chautauqua County's opt-out communities. Those school districts who will not participate in the exemption program. That doesn't affect you if they pay all the property taxes for the assessed value increase. But the assessed value increase, the way they word it is, it's the initial cost, and in 15 years, they're not saying they're going to pick up the cost after 15 years.